Welcome to Legalized Negligence. Tonight, Travis and I are going to take a little departure from talking about Florida Statute 768.21, subsection 8, because the legislature has gone out of session and nothing happened with that. So, thought we would do a short podcast to give an overview of a court case that Travis has ongoing at the moment. I'm going to let him do most of the talking here because he's got all the details of it. And basically, what he has done is gone into court and he filed a Title 42, which is under the U.S. Code, uh, Section 1983 civil rights case. And I'm going to ask him a couple of questions to get started on this. Travis, how is this different than filing a lawsuit for medical malpractice? If you were doing medical malpractice, you would go into a civil court, you would file a claim against the doctor for his negligence. What is it that this case does?
Well, this case is because I can't go in and file a medical malpractice suit. In fact, I can't even get the pre-suit done because I have no attorney to do the pre-suit. Likewise, the defendants don't have the opportunity to defend themselves during the pre-suit because of 768.21 subsection 8. So what I am doing is I am challenging the constitutional aspect of the law under Declaration of Rights of Florida's Constitution.
Okay, so I know about roughly a year and a half ago, I started talking to people about a 14th Amendment challenge because I got that from what Justice Periente and Chief Judge Schwartz had to say, her in the Mizrahi case and him in the Garber case. And he said he would have liked to have seen this case brought under an equal protection and due process challenge, which would have placed it under the 14th Amendment to the federal Constitution. So, how does your case differ from that?
Well, the defendants are actually stating this Mizrahi case, and my statement is that Justice Periente stated she would have liked to have seen this brought under strict scrutiny. Another justice concurred with her, joined in on her opinion, and basically there's statute or case history. I know you hate that, but this vernacular, where you can challenge a law based on present day conditions. So this law was passed 34 years ago on those conditions. So now the challenge will be based on present day conditions.
And what Justice Periente said is that we don't know, even if there was a crisis in the state of Florida back in the late 80s and 1990 when subsection 8 was passed. She said, I'm not convinced that the crisis continues to exist today. I think those were her exact words. So, what you're trying to do is have them reevaluate it to see whether or not the crisis still continues today. And if I remember,
Correct.
we talked about there was a case back in the 1930s, 1938, if I remember right, Caroline Products. And that's where this all began. And then later in the 1950s, there was a follow up to that, Williamson v. Lee Optical. And it was about whether how the case was reviewed in 1 year doesn't necessarily mean that 2 or 3 or 4 or 5 decades later, it would be the same issue. Am I following you correctly?
That is correct.
Okay. So now, did you file this in state or federal court?
I started out in the state, but because I'm pro se, I made some errors and it was removed from state into federal court. I objected to jurisdiction because it's state constitution. So I had to make some corrections. However, the removing attorney kind of jumped the gun and didn't notify all the other defendants, and that caused a procedural error, which allowed it, in spite of my objection, to be remanded back to state. So now the federal case is mooted, it's done away with, and now we're back in state.
So, okay, well, we can go into depth about that part of it later on, because I want this to be, you know, a 4 or 5 part series where we talk about that. And once we get everything you've done so far covered, then do podcast as your case moves along. And that way people can follow it. They'll understand what's happened so far, or what your purpose was, what's happened so far, and then you'll keep everyone updated as it moves along. I don't know that people understand the significance of this, but from what you shared with me, if you're successful with this challenge, subsection 8 goes away. Am I correct?
That is correct.
Okay.
And everybody who was denied from day one will be able to file until the Florida legislature puts something in place to correct, change, prevent, use your word, from those filings from going in. So have your stuff ready.
Basically, what you're trying to do is get the question before the Florida Supreme Court again.
Correct.
Okay. And so we'll first of all, you said a moment ago, because you filed pro se, explain to people what pro se means.
Pro se is self-represented. No counsel, no attorney to take the reins for you and help you and be sure you dot your I's and cross your T's and do everything right.
So you got a lot of learning to do along the way.
Yes.
Yeah, which is an extremely undue burden, in my opinion, that because of subsection 8, this is the level of work that somebody has to go through, that is extraordinary compared to people who could get into civil court if they didn't fall under subsection 8.
Right. And it's the huge thing is that there's no good information on how to do things for pro se. Simple stuff. I had to ask, but the clerks can't technically tell you because they can't practice law. No attorney is going to tell you their opinion on how to do things because they don't want to be the one representing you because they gave you an opinion. So it's really through trial and error, mostly through error, that you end up having to make corrections. And it's caused a lot of heartache for me. It really has.
Okay, so that
and timeline, timeline, you'll get like 20 days to respond to something. And for a law firm who has 2 attorneys working the case with paralegals and such, able to do research and all, it's a breeze. They got software for that. For the pro se, no. And someone with a learning disability, it's even more strict, more a burden, so.
well, just so people who
I couldn't imagine, sorry, I didn't mean to interrupt, but I couldn't imagine a pro se litigant who has a visual disability or other learning disability. The timeline would just really destroy their efforts, in my opinion.
So for people who watch this video, I want to make it clear, this is not a medical malpractice case. This is a challenge of a rights deprivation that you're trying to get up to the Florida Supreme Court. Of course, you have to start at the state local court in order for you to work your way up there. Is that correct?
Right. I have to stay outside of the realm of medical malpractice for my claims. So there's the defendants, the people, and then there's the statute that I'm bringing claims against.
Okay.
There's the claims, 1983 Declaration of Rights, and then there's the people and whatever tort I apply to get remedy. on them. That's what's going forward.
Okay. And you've been working on this for how long now?
On them, well, since my mom died,
Right. I know that,
September
but I mean
23rd.
specifically the 1983 case. You started like
Oh,
really starting to assemble that when?
oh, that I got a late start because I spent all my time trying to get under HIPAA the medical records, because without the records, I couldn't really have anything to give to an expert witness. If one would talk to a pro se person. Um, so I spent the majority, almost up to a couple months before my statute of limitations ran out, that I thought I had. Um, then I switched over to the legal side, because for me, the documentation would prove everything. But if you can't get the documentation, how do you prove anything?
Mhm.
So I was leaning heavily on the HIPAA aspect. And I finally, December 18th, I got new documents. I filed a new HIPAA request on December 15th of 2023. I did it on the hospital directly, and I did electronically on the hospital, knowing that the electronic one would go to a third-party provider. That third-party provider ended up giving me 103 pages, with the majority of them being new documents. Now, this is after the hospital attested to HHS OCR, Health and Human Services Office of Civil Rights, that they had given me all the documents. So I got paper stamped with dates that shows that I got new stuff after they attested to the government that they gave me everything.
So
But there's no right of action under HIPAA. You and I cannot bring a claim under HIPAA. We have to file a complaint and let the government service it, but we cannot bring it.
so what you just explained to me is that right after your mom died and you suspected that malpractice had occurred, you requested your mom's medical record and they sent you something, but you believe that they had not sent you everything. So you went back and requested more documents, and now you just got 100 and how many additional documents?
Well, there's the cover page and my HIPAA request, whatever. The total PDF I received was 103. Take some pages off for what I gave them, and then some of it is duplicate. But I would say there's probably at least 60 pages that's new.
That they had not given to you before. And as we've discussed in prior podcasts, you had already figured out from what you got from them in the beginning that there were like images missing. You found out later that there were things that they should have sent you that they never did, like dictation notes, all sorts of correspondence between various players, the hospital doctor, various people, that when you requested everything, there was a lot that they didn't send you. And I think they do that because they don't expect you to know that you can get that stuff.
Right, right. They were pretty much focused on like billing and medical records. But even with that, they didn't even give me the bill that I paid as part of the billing records. So right there, I know that I don't have everything because they didn't give me my own bill. Also, they tend to give you the final record of stuff when HIPAA allows you to get every revision of records in every form also.
Yeah.
So let's say they do a voice dictation. Well, technically you're due that audio. And also in some software, you can have notes that are entered in the electronic medical records software, or EHR, electronic health records, that don't print. So the only way to capture that is to go in and do a screen capture or photo of the screen, because it doesn't print.
Yeah.
You're entitled to that under HIPAA. They never gave that.
Yeah. So what I'm seeing is that people who fall under subsection 8 are at a tremendous disadvantage because number one, they can't get an attorney since you can't recover non-economic damages. The attorney doesn't have any way to get paid. And so now you're left on your own to kind of figure all of this out and not have the assistance of an attorney with 25 years of experience, knowing what to ask for, knowing how to get around the tricks that they play on you, the delays that they give to you. It's like I remember you telling me before that something you had requested from ACA, it's like 3 years and they still hadn't sent you what you requested. Um, but if you could get an attorney to work with you, an attorney could light a fire under them and get them to provide that
Correct.
information. So yeah,
Yeah, they know the procedure. They know what they can and can't get away with. They know how to file subpoenas and such. You know, there's forms that will show you how to fill out the form, but it doesn't tell you how to necessarily file it. And I'll give you an idea, like summons. Okay, when you go in with a summons, you need 2 copies. Okay, I went in with one. That right there blew a day for me. So I had to go back the next day, file my summons. It's just the little things that add up. And when you have to do 12 defendants,
yeah, and
it's a lot.
that's the part that I don't think the legislature realized what would happen. That when they created the class of people who were then going to fall under subsection 8, they put us at just this tremendous disadvantage over anyone else. And that's the rights violation that you're trying to fight against.
Correct.
Yeah. Well, I know we wanted to keep this one short because it's kind of just an overview, but some of the things that we're going to want to talk about in upcoming ones here are the other things that you've done so far, like how you filed your claim, how you got the ball rolling, and in a civil case that would be called the complaint, filing the complaint, and that's like the first salvo in a war. And so you'll tell us about how, what you had to go through to file the complaint, and then the response, or in legal terms, the answer that they would file and give you back their answer to that. And then all the steps that you had to take along the way to get you to where you are now. And then once we get however many podcasts it takes to do that, and we'll try to keep these things short, around 15 minutes or so. Um, then you'll keep us updated as things move along. Once you get us current, then when something new happens, we can do another podcast and update it. And I think this is a tremendous thing for people to start paying attention to, not only because if you're successful, it will do away with subsection 8 and open the door for everybody who's had their rights violated since 1990 to be able to do something about it. But it also gives us something to do throughout the next 10 months while the legislature is out of session. I know that I'm working on a project right now that is probably going to take me the next 4 or 5, maybe 6 months to complete, that I plan to have ready when they start holding their delegation meetings in the fall. Now, you mentioned a moment ago that everybody needs to have their documentation ready. Tell me what you meant by that.
Well, if God willing, the Supreme Court comes back favorably, there will be a window that you can file your case, and the legislature will undoubtedly be lobbied to fix that, or to take away our right again. I don't mean fix, take away our right. They'll try to prevent it. So they'll have to go through their process of votes and committees and whatever. And so however long that takes, figure a minimum of 1 year to pass a law. So you'll need to have yours in before they do anything.
And what is it that you're suggesting people start to gather and prepare and have ready to go?
I would say if you have probate open, you have the ability to subpoena records and such, do discovery on third party people. I would say either subpoena or file your HIPAA request. I would say do your HIPAA first and be sure you get everything in the designated record set. Use that and use like any and all records.
Have you come
Um,
up with a list of that? Have you compiled a list of what all of those things are?
Not definitive because I haven't discovered how everything is referred to. Um, it's like in software, like in the Epic software that I believe the hospital uses, there's those notes uh, that don't print. I don't know what the terminology for that is. It's given a name, quick note or something like that. But each software company, probably calls it something different. So how do you give it a name in your request when you don't know the software that they're using? Billing, it's kind of obvious, but you just don't know all the type of records that might exist to call them out by name. So you almost have to just use the generic everything and any and all records. And record is defined in the statute, in the statute of HIPAA, under designated record set. Look that definition up. And, in layman's term, it's any and all records that have private health information related to it, even the metadata of a record. If something is stored electronically, well, there's metadata. When that file was created, modified, who created it, that's the metadata. That's accessible to you. And I would say be sure to get the audit trail because the audit trail states who did what, when they did it, who created the record, who deleted the record, who edited it. You need the audit trail because then you'll know if stuff is missing or not.
Well, this is why you've heard me say over the last year that, everybody has something that they can contribute to this cause. They might not, they might not know anything about medicine. They might not know anything about law. They might not want to read court cases but there are things they can do. And this is a good example of something that someone can do. If there are nurses or doctors or x-ray technicians or anybody out there who works in a hospital, they could provide us with that kind of information. Oh, I know what you're talking about, Travis. We use something called, like I know the big transcription one is called Dragon. That's the name of the software that they use for that. And people could chime in and start helping us put all this together to benefit everyone. There could be people that there's got to be someone in the audience that knows how to build a website. They could help us with in that way. There's always something to do. And I guess what I'm getting at is just because the legislature is out of session right now does not mean that you should be sitting back ignoring this, waiting for them to go back into session next year. Now is the time that we prepare, to go at it head on next year. So is there, uh, I,
Let me let me let me just read the title of my challenge just so it's out there.
okay.
It's a plaintiff's notice of state of Florida constitutional challenge and contemporaneous U.S. constitutional challenge to Florida statute 768.21 subsection 8, aka Florida's free kill law, utilizing the strict scrutiny standard of review and notice of question of great statewide importance. With that, I filed a motion to stay proceedings pending the constitutional challenge of Florida statute 768.21 subsection 8. So that's the title of what I filed.
Now, I know that you provided me with something and you actually had a case number on it. Can that case number be researched somewhere if somebody wanted to go on the web and read about this?
Yeah, they could go, for me, I go to hover.hillsclerk.gov, I think it is, but it's case 23-CA-015470.
So they can go to that website, type in that case number, and they can read about the case that you filed.
Right. They may, like Pacer is at the federal level. It searches all of the federal courts. There may be other, court roaming sites that they could go to and put that case in and
Okay.
get it.
All right. Well, unless do you think that covers a pretty good overview then for people to kind of understand what we're going to be doing in this series?
Yes.
Okay.
Yeah. That's a good intro.
All right. Well, then we will be as your time allows, because I know you got a lot on your table right now, man. As time allows, we'll do another video and another video and kind of let you lay out all of the details of this. And I encourage people to try to get involved. And I mean, here he is. What Travis is doing is so big. If people would just understand that, um, and don't let all the legal terms and all that throw you off. I mean, take the time to listen to us and to learn what's going on here, because he can really help every one of us if he is successful in this case.
Yeah. And I know there's been concern about, charges of like court costs and stuff, attorney's fees coming back on me. But if there's nothing frivolous about a constitutional challenge that's been certified by a judge, that's not a frivolous case by any stretch of the means. And, if you have your evidence that you can show you got documents that weren't provided to you, well, that's not frivolous either. So, yeah, you need to be assured of yourself, but it will protect you. The more you know your own case, the better you are. And I encourage people to look in, to get the HIPAA stuff in, and get the records, and have it ready for an attorney.
Yeah, and they can always go back. We've got roughly 40 podcasts up on YouTube right now, and we've done podcasts on that. I think, if I remember right, we did one specifically on HIPAA and how to request things. You explained how to request things from HIPAA or through HIPAA. Um, it's all out there. You just have to dedicate the time to learning how to do it. You just got to make it important enough to get involved. So, well, Travis, I appreciate your time tonight, and we'll keep everybody updated as we go along.
All right, sounds good. Thanks for having me.
All right, man. Don't go anywhere. I'll talk to you as soon as I stop this recording.